Hello everybody, we are here today to talk about legal and regulatory considerations for digital assets. Here with us is Dr. Jason Graham-Allen of the Cambridge Judge Business School, Centre for Alternative Finance. The Cambridge Centre for Alternative Finance recently issued a report titled Legal and Regulatory Considerations for Digital Assets. So if I could ask Jason to introduce himself and the many hats that he wears, and he will then go through some of the main highlights from the report.
Great. Thanks so much, Ian. And thanks very much for the invitation to share some of the key findings of this report with you. Myself I'm a full-time academic. So in my research, and I know that, the CCAF community broadly likes to really keep, a close and an open dialogue with the industry. And so it's great to be here, and thank you very much for the invitation. Today I think I'll just run through at a fairly high level some of the key findings of the report. It's freely available on the CCAF website under publications, and I think as all of our publications, and so feel free to butt in at any time as well. If any sort of questions arise, and we'll have the opportunity at the end to have a chat as well. So yeah, I'll start sharing my screen. Mm-hmm. Here's something I prepared earlier. There we go. So this report was written by myself and three of my colleagues at the CCAF, Michelle Raux, Apolline Blandon, and Keith Bear, based on a consultation that we ran for the Stock Exchange of Thailand about a year ago. And in the course of that, we had a number of sort of stakeholder consultations with market participants, but also with different Thai regulators, including the Bank of Thailand, and of course, the Stock Exchange of Thailand itself. And so the SET has very kindly then given us permission to draft this sort of independent academic report for wider dissemination. And so I'd just like to thank the SET and also in particular their legal team, as we spent quite a bit of time with their regulatory lawyers in preparing this. So the report really required us to, or that brief required us to look at the Thai legal and regulatory framework around digital assets. As you may be aware, Thailand has a mixed legal system, so it's based on civil law, ultimately based on sort of Roman law. I think they've taken most from the sort of French civil law model, with some other elements, including some common law sort of transplants. And then in the digital asset space specifically, we've got a number of ad hoc regulations, including an emergency decree on digital asset businesses from 2018. What we sort of quickly realized is that the SET's, regulatory practicing lawyers were really the ones that were best placed to answer a lot of the questions in sort of Thai regulatory law. And we saw our value add in sort of taking a step back and providing some comparative perspective. Looking around at what was happening in other markets and jurisdictions around the globe. And also maybe delving into some of the questions that, without meaning any sort of denigration, but the kinds of questions that a lot of practicing lawyers or practitioners and in-house lawyers potentially aren't going to grapple with. So we noticed that there was really a trend, especially following that 2017 summer of the ICO, that there was a real flurry of regulatory attention because, like, boom, the mainstream was taking this stuff seriously, and that's perfectly perfectly reasonable. There were really legitimate financial stability and investor protection concerns. And regulation has the advantage of just moving more quickly. What we sort of noticed while writing this report, and I think that developments sort of subsequent to that around the world vindicate that to a certain extent, is that there were a number of really core sort of nuts and bolts private law questions that were either not being answered fully or were not even being asked. And a lot of assumptions being made, about the fact that, for example, if you and I, we set up this new sort of digital information, architecture, and then we start, treating values recorded in that ledger as sort of, having economic value, we expect that the law, and we assume the law is going to reflect that. Now, obviously there's an element of the crypto movement that says, poo-poo, we're not actually interested in state law and we don't need things like property rights and so forth. I think, especially now, we're in another, fairly hot phase of crypto sort of market development, with a lot more institutional involvement and the involvement of a lot more sort of conventional types. Apparently now we have a lot more over 55s. It's not just crypto bros, it's women. And a lot more people perhaps with more conventional expectations that the law is actually going to, sort of provide some background, not just regulation, but also facilitation of these sort of economic and financial transactions. So yeah, in this report, we concentrated on some of these private law questions. This gave us a bit of an opportunity to return to an earlier study that we'd collaborated on, the Global Crypto Asset Regulatory Landscape Study from 2019, and sort of cash out on some of the findings that we made there. The report is, the structure is pretty simple. There's 4 substantive parts and then a list of key findings on the last couple of pages. And I think in the next sort of few minutes, I'll just walk through each of those. So the first part, we deal with asset taxonomy, and this is something on which reasonable minds differ. There's definitely different approaches and different opinions on how we carve things up. I think there's, at the outset, I'd say, every taxonomy has a purpose. And so, the sort of success criteria for a taxonomy will also depend on what you're sort of making that taxonomy for. But the approach that we've taken at the CCAF now in that 2019 report, and again in this one, is really to draw a distinction between crypto assets narrowly defined, and then other types of digital assets. Now, the border between, here we've got just a very crude little diagram with 3 concentric rings. The border between that widest ring and the middle ring is kind of fuzzy, and we don't really set that down in the report. And that's one of the things that I know I myself and many others are currently grappling with. At its very broad as digital assets, I mean, our browser history, for example, we know it has immense economic value, but it's not the kind of asset that we're talking about being, for example, traded on an exchange or something. But actually narrowing down, that middle category is a non-trivially difficult sort of task. But the core distinction that we draw is between crypto assets, which just sort of exist. They just represent that they are there. They are in permissionless open networks. There's no sort of readily recognizable formal issuer. And they certainly don't give, or they don't purport to give their holder any right against the counterparty, or in anything that exists sort of, off chain or in the real world or whatever. Whereas whether or not something uses DLT, other applications of DLT will sort of, make usually an ERC20 or whatever token, which then represents something that's like a company share or like a company bond, or, like an interest in a piece of gold in a vault or something. These two categories potentially raise different regulatory, but also different sort of private law legal questions. The important thing, I think, to note in the context of digital assets more broadly, is that, they may use DLT or they may not. And, we sort of endorse the idea of technology neutrality to the extent that, a DLT-based company share should be treated like a company share, and not necessarily like a crypto asset. So on the basis of that distinction, and we do think that drawing that distinction very clearly at the outset just sort of helps one to ask the right questions sort of further down the line. In section 2, we look at some legal and regulatory implications that arise in the context of crypto assets and in the context of digital assets in this broader definition. For crypto assets, the primary legal question is really, how does this thing behave in the conventional property law system of the relevant jurisdiction? And that differs actually quite a bit from legal system to legal system. So on sort of the one extreme, we have certain civil law jurisdictions based on a certain reading of sort of the classical Roman civil law sources that say, look, to be a thing, that can be owned, an object has to be physical, it has to be corporeal, it has to be spatio-temporal, and I have to be able to hold it. Others in the sort of broader civilian legal family, they're quite happy to treat rights against others and rights in things as if they were things. And we can talk here about reified rights, from the Latin res for thing. And then, we have the common law systems, which are fairly open textured. We tend not to take such strict sort of dogmatic definitional approaches to these things. But there are still some questions about, for example, Bitcoins, how they fit into the conventional taxonomy. In the common law systems, we tend to work with, a big distinction between choses in possession, or things in possession, and things in action. The problem with a Bitcoin is it's not obviously a thing in action, because it's not a right against anybody, anybody recognizable. But it's also not a thing in possession, because possession in the law means physical possession. And we haven't yet got to the stage of having a legal concept of possession that applies in digital spaces as well.
May I just jump in there, Jason?
Yeah.
I was just considering the financial services industry, and we know that many countries, especially those in Scandinavia and the UK, are pretty much completely doing away with the use of cash in society. So we also know in the central banking relationship with financial institutions in most advanced economies, 98% of all the transactions are done electronically. This is how advanced economies work. So you could argue that we're already making steps towards understanding the digital world. And I like what you do on this slide when you highlight these challenging areas. And I would bring also to your attention a test case in the UK at the end of last year regarding a particular business in Canada that was held up to ransomware with regards to having to pay the ransom in Bitcoin, and the particular company's insurer took this to the courts here in the UK, and the court, if I recall, deemed that the particular, through the use of blockchain analytics company, could identify where the private addresses of the wallets from the ransomware hackers had actually ended up on a VASP, a virtual asset service provider, trading exchange, if you like, and therefore issued an order to over those bitcoins. So does that not tell us that Bitcoin is property?
For the purposes of English law, and in that context, it absolutely does. I think, you know, England and Wales and the common law countries, or the common law jurisdictions more broadly, I think are pretty well positioned to kind of take this in their stride. You know, you may be familiar as well with the 2019 legal statement on crypto assets and smart contracts in English law. You know, that takes a very, I mean, you know, the common law and common lawyers kind of have the cliche reputation in comparative law circles for being very commercial and very pragmatic about things, and, you know, being less fussed on sort of fine conceptual distinctions. But I must say, you know, having some contact with the English, you know, the London sort of legal profession, I think there is a very commercial, pragmatic attitude there. And I think there is sort of, you know, a broad commitment to the idea that, look, you know, obviously there's going to be some hard limits, but, you know, generally, if the market is sort of, you know, doing a thing, it's the law's job to kind of facilitate what people are doing rather than trying to stop them from doing it. You know, I think we've got a case from you know, from New Zealand from earlier this year as well, that says, yes, Bitcoins, you know, can be property or are property for the purposes of, you know, being the subject matter of a trust. You know, we can compare that to cases like the Mt. Gox case in Japan, where Bitcoin holders were held not to be owners, and therefore they couldn't get a proprietary remedy over their Bitcoins. And that shows that, you know, there is some comparative advantage in you know, these different path-dependent legal systems. I would say, though, that in defense of the pragmatism of even our civilian lawyer cousins, you know, there is a, you know, I'm based in Germany now, and the German legislature now has a draft law on sort of electronic securities that basically will say, look, we'll treat certain types of you know, DLT based, or certain types of electronic securities, I think it's technology agnostic, as if they were things under section or paragraph 90 of the German Civil Code. It's a little bit odd because paragraph 90 of the German Civil Code says, in terms, things within the meaning of the law are corporeal things only. And then this draft bill is saying, well, electronic securities are like non-corporeal, but we'll treat them as if they were things under paragraph 90. You know, it's a bit of a duct tape job, maybe, but it gets the job done, and it will work fine. I imagine in practice. So there will be workarounds for it all. I think in the point you make about money dematerializing, and the declining importance of cash as opposed to other digital sort of forms of money is so important. That's actually what got me working on this sort of digital asset and property question in the first place. My sort of broader research is actually on monetary law. And, you know, the law of money, until, I think we can say, well, I'll put it this way, until 1991, the sort of major treatise on the English law of money, which was F.A. Mann on the legal aspect of money, said in terms, you know, money is cash and banknotes only. Money is a chattel, it's a physical object which is issued under the authority of a state. And we can, you know, bracket out the whole state theory versus market theory and so forth. But, you know, for man, and he defended this right up to the end of his life, actually, even though we had, you know, credit cards and we had, you know, digital bank account money, and economists were treating, you know, these things as broad money, you know, all along. But, you know, he sort of trenchantly insisted, no, money's true money. Money is really just banknotes and cash. Since then, I think, you know, that traditional position doesn't really have any defenders. I can't think of anyone who I know who would sort of, you know, really like, you know, really pin their colors to that mast. But I think there is still a degree of uncertainty about, you know, how this new world works, or rather how the law, you know, works in this new sort of world. Yeah. So thank you for that intervention. And I think, you know, things like the dematerialization of money, the growth of you know, the advent of sort of like these digital commodities, these purely digital objects like Bitcoin, really force us to finally answer some questions that may have actually been kicking around for a while. And we may have been kicking the can along the road, you know, for a little bit, and now we can't kick it any further. We've actually got to get down to brass tacks. And
yeah, well, I agree with that. In its simplest form, all of the UK financial institutions have an account with the central bank, and that's just a record kept in a digital ledger. And that's exactly what the Bitcoin blockchain is. It's a record of transactions. And so we have seen this before. It's just now becoming more and more focused across the broader spectrum of society.
Yeah, absolutely. And so, you know, we have that main question with things like sort of, you know, crypto assets as we define them narrowly, where the main questions are, you know, how do these fit in property law in the broader sense? What pigeonhole do we kind of put them in? Do we need to create a new one in any legal system? Do we use sort of some workaround, or, you know, duct tape solution? Do we amend the sort of central provisions of the civil code? How seriously do we, you know, at what level do we want to address this? And that's all going to be highly jurisdiction specific. For digital assets, sort of that broader category, as we've defined them, they might be DLT based or not DLT based. They might be a more or less open DLT system and so forth, but they give their holder, they claim to give their holder, they're assumed to give their holder a right against the counterparty or a right in a thing. And these are easier to sort of fit in pigeonholes because they fit in English law quite nicely into the category of shows in action. And they fit quite nicely in most civilian legal systems into sort of, you know, a more or less accepted category of you know, res in corporalis, you know, this right being treated as if it were a thing. The legal questions that are going to arise here, though, are also difficult and also very important. And that really relates to the, you know, the legal nature of the link between that digital token, whatever it is, whether in a centralized, you know, registry or on a DLT ledger or whatever, but the link between that digital token and whatever that sort of you know, real world asset is, be it a right against the counterparty or a right in a thing. And so I think in the report, we refer to it as a bridge. Other people talk about it as a link. The Liechtenstein trustworthy technology law that I think was released earlier this year uses the metaphor of a container, and it says these tokens are like containers, and they can be empty, as in the case of, you know, how we would define crypto assets, or they can have have rights in them. But making sure that we're not making unjustified assumptions about this link, and its bidirectional sort of travel is really important. So, for example, let's say we tokenize some real estate or something, we need to be very sure within, according to the national law of the jurisdiction where that land is located, we need to be sure that, by dealing with this token on some crypto exchange, that we're actually dealing with legally cognizable rights in the land. For a long time, trading in bullion has been restricted in some jurisdictions. So we might need to be careful about what kind of rights a digital token actually gives in the thing. In all cases, we need to decide, do we want dealings on this chain, for example, to be, to actually affect or cause or bring about a change in sort of the state of legal reality, the legal state of affairs? Do we want to be evidence of a change in the legal state of affairs? Or is the law going to come around and say, well, it's irrelevant, whatever you've been doing, in this sort of ledger of yours, it's not doing what you expected it to do. And I think that's just really crucially important if we want, markets in these assets to mature, to be attractive to, a broader and especially, institutional investors, and we really want, sort of certainty for everyone involved. So that's the main sort of upshot that we see for digital assets that are not crypto assets. And it does get very complex because it touches almost every sort of conceivable area of law, and so we don't go into a huge amount of detail.
Just before you move on to the next slide, Jason, I just wanted to ask your view actually with regards to, specifically in the UK, we recently had a public consultation that closed around crypto asset promotions. And we noted at CryptoUK when we were responding to this public consultation that the approach of the UK government had somewhat changed from the previous iteration coming out of Treasury when they produced a crypto asset task force report a couple of years ago, where they were using the pretty standard taxonomy that you mentioned before, where we have a payment / exchange token, a utility token, or a security token. It now seems that they've come up with this broader approach, which perhaps, and correct me if I'm wrong, feeds into what you were discussing there around the digital and crypto tokens, where they use a definition of transferable and fungible. Can I ask, in your view, do you think that's a better representation of how to define crypto assets, because they can be so broad and varied?
Yes, I think it's certainly useful in terms of drawing the perimeter between this sort of broadest category and the inner two, because most of the assets that we're talking about within those two inner circles are going to be transferable and fungible, and that's I think a very relevant sort of set of characteristics. I think, I spent quite a bit of time yesterday thinking about this crypto asset promotions definition, and I think it really does converge with the approach that we've advocated quite a lot. I have a feeling there are still some differences, but it's certainly, I found it more difficult to find where those differences were than with sort of the standard, tripartite exchange, utility and security tokens. I think, there's still value. And again, like I said, definitions, it really, you can have different definitions of things for different purposes. So to use an example from German law again, electricity is not a thing under German law for the German law of property, but they sort of dealt with cases, fairly early in the 20th century where people were filtering electricity and I think also heat. And so as I understand it, and I'm not a German lawyer, so there's a big caveat there, but as I understand it, they said, well, electricity is obviously not a thing because it's not, spatiotemporal and we can't hold it, and it's, but we'll treat it as if it were a thing for the purposes of criminal law. And so, I would not denigrate, the value of definitions that are sort of led by regulatory considerations, especially in the first instance. I think there still is value in terms of, thinking things through, and I guess especially for market participants, for like market actors themselves, but thinking things through and thinking, okay, well, what am I actually doing here, and what sort of technology am I using to do that? And absent sort of any regulation, thinking it through in terms of its private law definition and characterization as well.
Mm-hmm.
And I think, to the extent, the one point of difference that I might see is that this category, I think, of unregulated security, of unregulated tokens that the crypto asset promotions definition sort of takes as its point of departure, it seems to me would still include what we've defined as crypto assets and digital assets that are not crypto assets. And if it does, then it might still be, eliding or obscuring important private law differences in the way that these things will actually, work in a market where property rights are traded, essentially.
Okay, thank you.
Yeah. So part three, you can tell it's been a long day, moves on to talk about activities and actors in the digital asset ecosystem. And in this context, I'd really commend to you the I think the third crypto asset benchmarking study that the CCAF has just released in the last month or two. That gives quite a breakdown of how the market is developing and so forth. But I think this is quite a useful section for regulators and also for market participants. We try to really break down and again taxonomize and work out, well, hey, who is doing what in these markets, and what are the different stages of the life cycle of a token, or of a digital asset, sorry. And what are the different sorts of service providers? How can we sort of differentiate and classify them? And on that basis, we try to sort of identify, where there's going to be competition with incumbents, where we're offering new services, for example, infrastructure and ancillary services that just didn't exist before, because, it's a novel infrastructure. And we hope that this will be a sort of a useful tool to sit down and maybe identify where some regulatory issues and possibly even issues with business models or opportunities might arise. Section 4, I think, is worth a look. I think it's quite an interesting section. It's the product, and originally we had sort of a mind map, which we then put into this boxy sort of a table in the final version. But we sat down with a lawyer, an economist, and a computer scientist, and tried to just think about what's an asset. Why are certain things treated as an object of value, and traded between economic actors. What makes it the case that they can be treated as an object of economic value and traded between actors? And the different ways. This is, I think, from the third dimension. We look at 4 dimensions. The rights that it gives you, the representation, the sort of form that it takes, and the other 2 slip my mind at the moment. But here we're really asking what impact the form of an asset has on the way that it works. And this is meant to be agnostic as to legal system, so that people from different legal systems can look at it and say, oh, okay, well, if an asset is registry based in in a register which is controlled by a single entity, my legal system would treat it as such and such. Or if an asset exists which is really just like a digital file, but it's not a register asset, my legal system would treat it as such and such. And we've sort of tried to give examples, and obviously the shared registry, which is, that's really the big one that we're most interested in here. We can again start to think through the problems. What challenges do open shared registries of intangible assets pose for a legal system? And why is it that an open shared registry of intangible assets poses different challenges to a closed one, which is not controlled by a single entity, but controlled by a smaller group? And on that basis, you can start to think as well about how do different consensus protocols work, for example, and what legal issues might different types of consensus protocols raise. So this is by no means the final word, and we really hope it's more of a stub that we can develop in later work. Mm-hmm. And so this would be one thing on which, if there's feedback from the industry, we would, we'd love to get it.
Well, I think this is a very interesting slide, because it's impossible to future-proof any technological industry, especially this industry. What we're seeing with such things is decentralized finance, and the folks that are building these really interesting and new products around, say, financial markets and services are grappling with these questions right now. Conceptually, how do you incentivize people to bootstrap a network? And then the governance needs to be coded in to the protocol, and how does that operate? So no, that's very, very interesting. Thank you.
Yeah. And that's, that's basically an overview of the report. And I just sort of, finish my spiel with sort of a nod to some of the work that's going on, especially in the private law space. So Louise Gullifer runs the Oxford Digital Asset Project. It's got some great members, and they're building a really great database of sources on the legal treatment of digital assets. There's law reform projects at the national level. So I think recently the Law Commission of England and Wales has just kicked off a project. I think this is correct, that it's on digital bills of lading in the first instance. And so the Law Commissioner for Common Law and Commercial Law, Sarah Green, is really fantastic, and is leading a wonderful team on that. And I think we can look forward to a really worthwhile report that will build on that 2019 legal statement from the UK Jurisdiction Task Force. And then there's more, but these two I'm involved with. There's a European Law Institute project on access to digital assets. So they take a bit of a broader view of digital assets, because they are interested in things like digital image files on social media networks. If I die, how do my heirs get access to photos from Facebook, for example? Mm-hmm. And they're focusing on that question of access, and less on some of these taxonomic and definitional questions in the purely sort of commercial space. By way of contrast, UNITROIT, which is a UN body tasked with the harmonization of private law, there are, I think, 62 or 63 member states representing over 90% of GDP, and they've just kicked off a project on digital assets in private law. There's also a project on best practices in enforcement, which contains a component on sort of new issues in enforcement potentially raised in the context of not just digital assets, but novel technologies generally. So again, my message, I guess, to the industry would really be law often appears as a bit of a brake on business models and as a reason why you can't do cool things and so on and so forth. But, private law especially also provides a huge amount of, I think, value to any business model, because it just provides this sort of default machinery which works in the background. And we've seen in a number of cases now over the last few years that things can and do go wrong, even in this space. And that when things do go wrong, it's nice to have a predictable and a certain legal system for all its faults of expense and speed and so on and so forth. But private law really does provide economic agents with building blocks to engage in the whole varied panoply of transactions.
Sorry to cut you off, Jason. I was just thinking about. I have many more questions for you for today, but time has caught up with us, so perhaps we'll have to get you back at another time. But just to touch on your point regarding the legal influence into this new industry, I can remember talking a couple of years ago regarding smart contracts and how smart contracts were going to put lawyers out of business. But what you see now is a lot of the legal profession doing a lot of great work. And you mentioned Sarah Green, and I know that she did some great work here in the UK regarding such things as remedy that you touched on, because there does need to be a rule of law. We do need to have recourse. And a blockchain does disintermediate and does provide some of the processes in between that we perhaps don't need, which benefits both in terms of speed and cost. But at the end of the day, if you have money in Mount Gox and you couldn't get it back, you'd rather have money today in, say, Coinbase and be able to have remedy to get it back. So I just think, it's worth noting that, and we appreciate all the good work that yourself and your fellow colleagues are doing to push forward the legal side of this industry.
Well, thank you, Ian. No, I think there has also been a cultural shift, and I think everyone is a lot more pragmatic these days as well. Mm-hmm. And that goes for the legal side. Instead of naysaying and poo-pooing, it's like, okay, actually there is a market here, so there's a need to engage with that, and indeed a professional and commercial opportunity for that. And I think there's also been quite a lot of maturation and pragmatism on the crypto side as well. There's been interesting debates about, for example, the interaction between smart contracts and contract law in within the crypto community. I won't get into the whole, is a smart contract really a contract? Obviously, most are not and don't purport to be. On the other hand, if we can make a contract on the back of a napkin, you and I, then I don't see any reason why we can't make a contract, that also happens to be sort of machine readable, that can execute in some runtime environment. And, in all cases, I think, the nub of it that we should rather look at directly than avoid is just saying, look, how is the law going to, respond to and characterize, this new technology mediated, social interaction or social phenomenon? And then in the second instance, how can we, benefit maybe from some of the experience, that's like encoded into the law, but also what do we maybe need to do to tweak the law to make sure that it's keeping up with the times? Mm-hmm. And it might well be that certain technologies like remove the need for remove certain problems that people have had, to which the conventional recourse has been to law and to the courts. And I think that's actually to be welcomed. But it's a little bit maybe like with AI. The whole point of automation is so that humans can spend time doing more important things, to which they can bring their human intelligence. And maybe it's the same in terms of the interaction between DLT and legal systems as well.
Well, there's some really interesting big questions there, Jason, and thank you again so much for coming along and giving us the highlights of the report, which, as you said, is easily available on the CCAF website, and you can also find links to this summary and also the interview we did with your colleague Apolline with regards to the third iteration of the benchmarking study. So if anybody wants to reach out and contact you, Jason, and to help you with any of the work, where can they get hold of you?
My email, jgallen@cantab.net, or through the CCAF. I'm based in Berlin, actually. I'm sort of currently a senior research fellow at the Humboldt University. So if anyone's in Berlin and cares for a catch up.
Post-COVID.
Post-COVID. Gosh, if we're ever allowed again.
Yeah.
No, so thanks very much, Ian. It's been a real pleasure, and I've very much enjoyed that. And it's always great to communicate one's research.
You're most welcome. Thank you. Goodbye.
Here.